SJC-12507, Rosanna Garcia and others, v. Department of Housing and Community Development.
Mr. Furgang, we're firmly into the afternoon. Good afternoon.
I was just checking my watch to fill the appropriate greeting, Your Honor. Good afternoon, Your Honors. Samuel Furgang, with me is Kimberly Parr for the Department from Housing and Community Development. The preliminary injunction issued below is based upon an error of law, namely that DHCD must treat motels as available placements when implementing an ADA accommodation request. But under the EA Emergency Assistance Program, motels are not considered to be available. Instead, by statute and by regulation, they are a placement of last resort when there's no when there was no contracted shelter space in the system. And that is not the situation we were faced with today.
Help me to understand. Somebody in DHCD has approved many ADA accommodation requests.
Yes.
And what is the finding that they make when they approve that accommodation request?
Well, if I can draw your attention perhaps to page 23 of the record, that contains a typical grant of an accommodation request, and I'll read it to you. It basically says, EA household to be placed in desired region to alleviate the symptoms of the diagnosed disability and access necessary medical care as needed when administratively feasible. So what happens there is that every family, as they come in, fills out a form. They're invited to list any disabilities that any individuals may have, what may be necessary to accommodate those disabilities. And the department then goes ahead and does whatever it can within the confines of the system to reasonably accommodate those disabilities.
But isn't that the issue as to what the so-called system is?
Yes.
So when somebody has a disability, you agree that you have an obligation to provide reasonable accommodation.
We have an obligation to provide reasonable accommodation so that that family and the individual with a disability has meaningful access to shelter. And that's what the department endeavors to do and has in fact done in this case. Every family that is subject to this class-wide preliminary injunction does in fact have shelter. That is the primary essential goal of the program. That is what the appropriation is for. And the outlines of that program, as contained in the line item, and maybe even more importantly in the regulations, make it clear that the purpose and the scope of the program is to use contracted shelter space for families. And they do that because they've come to the conclusion after many years of experience that that is the best way to meet
I understand
shelter
that,
needs.
but try my question. So there has been a determination that a person has a disability and that reasonable accommodation requires transfer of that person to a different facility to better accommodate their disability, correct?
When administratively feasible.
Okay, and so
That's
what is your position as to what happens in those circumstances when your own staff determines that a transfer is necessary reasonably to accommodate that household?
There's a placement office, there is a ADA office, and they endeavor to make that transfer go forward when an appropriate place becomes available for that family, taking into account the nature of the specific disability, the nature of the accommodation that they may need, and the nature of the overall needs of the system because of the ongoing influx of people that need shelter.
And does the record reflect what the average waiting time is for those persons to obtain transfer to a place that will reasonably accommodate their disability?
It does not, in part because the issue is one of looking at every family on a case-by-case basis. And here in particular, sometimes there's a transfer made immediately. Sometimes the initial placement takes into account a specific type of disability. But the concern we have here is that the court has required a class-wide immediate transfer to motels without looking at what those individual circumstances actually are and whether motels are in fact in any way a solution or the better solution to accommodate the disability. And in this case, the department has in general decided that it was not, which is why they were not transferred to motels in the first place.
So let me sort of step back. Do you agree that if the department were to say, yes, our staff person has determined this person needs a transfer for a reasonable accommodation, but we're not going to do it, that would put you in violation of law?
If ultimately the actual immediate transfer was the only way to meet a reasonable accommodation, that may well be true. But again, you can't, it's very difficult to make a blanket admission like that because you have to look at the specifics of the accommodation itself and the necessity for why a transfer may be required for that particular family. Generally speaking, again, because of the nature of the program, what the transfers that must be made in a relatively quick basis are based on the physical difficulties that a family may have or an individual within that family with a disability to get meaningful access to the actual shelter being provided. And then things must be done immediately if it means providing wheelchair access, if it means doing things of that nature that make the shelter physically useful. Here, for the most part, what is being contested is something outside of the provision of shelter. What is being contested, and again, not universally because the judge didn't look at each individual case, but the general tenor of the requests that are at issue here are ones where the family would prefer to be closer to a medical provider.
This is not an issue of preference. This is the judge's order is limited only to those circumstances where your staff has approved the accommodation requests.
Yes, Your Honor, but they've made that approval again within the context of the system and not made the conclusion that it's necessary immediately or.
And so what is is there any, I'm trying to get some sense of time, well, let's step back, okay? If there were to be a determination that this person needs to be transferred because of an accommodation, and the position of the department was that we are not going to transfer that person for that reason, would that be a violation of our disability law?
Well, if the determination was that that person needs to be transferred and needs to be transferred within a certain period of time. But again, here, because of the nature of what is being accommodated, there's a degree of flexibility, and the ADA recognizes that.
And so what, if there is an obligation to transfer people, what is a reasonable period of time to expect that that accommodation will occur?
It depends upon the nature of the disability. It depends upon the availability of an appropriate placement within the system. And it depends upon the prioritization of other people within the system that may also need a transfer. And again, that's something that the Olmsted case talks about, that when you look at a system of a certain composition, it may not be possible to immediately accommodate everybody that has a disability. And in those circumstances, it is reasonable to allow for some time to pass so that everybody in the system has equal access to shelter, and that when a place becomes available, that family or that person then gets that additional accommodation. But here, the hypothetical Your Honor is positing is outside of what the reality is in the system. And that is because, sorry, Your Honor.
I'm having real trouble. There's very little factual record here. And are you even challenging the class certification? I mean, there are a million ways of being disabled. Some have to do with wheelchairs and going upstairs. Others have to do with autistic kids who can't, be in a high stimulus environment. I mean, I just find this is done so abstractly based on anecdote that and Well, go ahead. Why don't you address that? Do we have a factual record that's really developed here to do any of this?
No. In a word, no. And that is, we did indeed contest the class certification for that very reason.
Wait, are you contesting it on appeal? I mean, the first thing, I had to go back to make sure this was a class. I mean, but is there any attempt to deal with the class certification issue in the briefs?
No, Your Honor. I mean, what we're dealing here is a request for interlocutory relief. The class certification is an issue that we would, if necessary, certainly
But you didn't
take up.
challenge, so you haven't challenged the class certification in this interlocutory?
No, Your Honor. Our primary concern was with the directive of the lower court that we had to immediately place people in motels.
Can I ask another factual underpinning? When the department finds someone, are they finding that they need accommodation, or are they finding that they meet the definition of disabled? Because to me, those are two different issues.
Well, the finding is, in a way,
What is the finding?
the finding is basically that in a way that the department acknowledges that certain families with individuals with disabilities have certain unmet needs, and those needs extend in many cases beyond shelter.
Certain unmet needs in the shelter they've been provided, or certain unmet needs in general and abstract? I just don't know what that means.
Well, and again, by virtue of the nature of this case, we haven't got the full record, and it varies from family to family. In some cases, there are unmet needs based upon the nature of the disability and their ability to actually take advantage of the shelter that's being provided.
So this is a finding that, that they need a special kind of shelter? What is it a finding of? Because again, I understand you can't put someone who's in a wheelchair in a walk-up, but I don't understand exactly, and you also can't put a certain kid in a congregate housing maybe, but I just don't, the judge jumps to the fact that we need motel rooms, but.
Well, I agree. That is our foundational concern with the nature of the order itself, that it doesn't differentiate between the specific needs of each family.
So
and
is that what is under this program is what's supposed to happen, that you get the first available room, whatever that meets sort of general, but if you have a disability, you're entitled to an accommodation, and then we're going to do an individualized inquiry for you. Do you agree that that's what should happen?
That is what does happen, and it happens from the very beginning when the application process takes place, and it continues to happen because the families, in some cases, may apply in the course of their...
So is the error, in your view, what the judge did was to decide, instead of an individualized inquiry, which is that the judge decides that motels need to be more generally available? Yes,
Your Honor, and more than that, there are two problems, chief problems with the lower court's analysis. One is just that in the absence of any kind of individualized analysis, there's a decree that motels must be used for every family, even though the department never came to that conclusion and indeed disputes that strongly across the board.
Do you agree with the chief's question then that certain families may not be able to be housed in the existing units except for in a hotel? Is that something we don't know yet?
We do not know yet on this record. Certainly, we would submit that is an extremely rare occurrence. It is a very rare situation in which the variety of shelter placements available within the scope of the program would not be sufficient to meet the needs of a family to receive shelter.
But the problem is, if you have a child that needs to get to Children's Hospital, 3 times a week, and they're set up in Lawrence, I take it that may require an individualized exception, right?
Well, what happens there we have to divide, again, there's two parts of that problem. Mm-hmm. One is working with that family to find some way to make that burden easier. Determine when the appointment is taking place. Is there an alternative provider that's close to the shelter, for instance? The other part of the problem, And the core part of the problem, unfortunately, for some of these families, is that it is not the role of the EA program to facilitate access to a medical provider in a specific location. It is its core obligation is to provide shelter for families who are
I
experiencing
agree with
homelessness.
that, but there has to be, the disability law has to kick in at some point, right? It has to require special, you agree, it requires individualized accommodation, right?
Yes, Your Honor. But the accommodation has to focus upon the nature of the program and the scope of the program. Here, the program is shelter and not the provision of access to medical services. And if I can contrast, there's a case the plaintiffs referred to in their case.
But if, for example, if the person's in a wheelchair, you can't put them in a walk-up, right?
Absolutely,
So that you would have to accommodate.
absolutely. And they are accommodated.
Okay.
Absolutely.
The question is when?
They are accommodated, my guess would be immediately. If they are in a wheelchair and they
Are
cannot...
we in the world of guesswork? That's problematic.
No, I think, again, Your Honor, that is a quintessential case of where a physical disability would deprive an individual of being able to take advantage of the actual shelter provided, and the department would, under the ADA, be required to find a reasonable accommodation for that person. And generally speaking, what the department does in those cases is find a ground floor wheelchair accessible place for that family right away. And if in some cases, unfortunately, that may mean displacing another family.
Where do you find the line between, in that context, or maybe a more complicated context, discrimination because of a disability and the adequacy of the service?
Well, again, that's the issue here that we strongly contest with the plaintiffs. And the core problem, again, is the issue of defining the scope of the program. None of the plaintiffs are being discriminated against in terms of access to shelter. And that's what the focus is under the Alexander case and under Olmstead. When you evaluate whether or not a person is being discriminated against because of their disabilities, you look at whether that person is not gaining access to the program provided by, the benefits of the program provided by that agency. And the benefits...
Put aside the, just following up on that and your answer, put aside any class certification issues. Is it possible in this situation with these findings to be able to differentiate when we're dealing with a discrimination issue as opposed to the adequacy of service?
No, there simply isn't a factual record because, first of all, the number of people that are subject to this injunction is a moving target.
And isn't the goal, I mean, obviously you can't, you want to have people as close to medical care as you can, even if it's a shelter program, but the overall goal, as I understand it, has been going on for a long time, is to move away from motels.
Yes, that is, again, they are, and I cannot emphasize it enough, in the line item and in the regulations, and I refer the court to the bottom of page 21 of our addendum, where the regulations talk about the fact that EA households shall be placed in family shelter when such shelter is available. Temporary emergency shelter may be authorized as an interim measure after the department determines there is no family shelter with space available. That is the core of the program. It has spent years trying to get away from the warehousing of families in motels and to keep them in a much more appropriate structure of contracted family shelter that is stable, that offers services, and that is able to absorb the families that come in on a regular basis.
Still don't see you answering the question about the ADA. If you're violating the Disabilities Act, then don't you have to do something perhaps outside of the program or the system that you have in place?
Yes, but we are not violating the ADA. That's the issue here. The problem that the court below did was he began with a finding of a violation and then went back to look at what the program was, rather than looking, and this is what the ADA requires. One is supposed to look at the program to determine the scope of what is required to provide to the clients of that program, and only then determine what is a reasonable accommodation to satisfy the disability needs of an individual to gain the benefits of that program. And the program, I keep saying this, I'm sorry, the program is shelter. It is not the provision of access to doctors. There are other programs that can do that. The ADA, the department attempts to work with these families to help them achieve that goal, but that is not the program. And if we start doing that, we're going to be diverting, as the court is forcing us to do below, we're going to be diverting resources away from the core program and spending it on something else, and that is going to cause problems for the people who are subject to the program. They're going to be losing access to the very benefits that this program is designed to provide. So what I'm requesting the court to do is allow the department to do its job, to make the individual determinations of need for every family, to determine what is the appropriate placement for those families within the program, and then when necessary, to transfer those families to more appropriate accommodations
Let
becomes
me
available.
ask you, if you have a family with autistic children, is it reasonable to say that they should not be in a group shelter under some circumstances?
Either that, or there should be some accommodation made within the group shelter to provide them with some kind of ability to function. And there are cases where they do. They provide, for instance, access to their own bathroom, for example, or they provide separate meal times. There are ways to work within the system to do that, and then transfer them to a scattered site type solution if that's what is necessary.
Let me give you a more simple example. If a person is in a wheelchair and there's no chair lift, if they're given a shelter, they have to accept it, otherwise they're out for a year, correct?
Correct.
And if they're given a shelter where they're placed on the second floor in a walk-up, do you agree that they have an entitlement to be transferred to a place where they don't need to be asked to walk, where they're in a wheelchair?
Yes.
And if there is no available shelter for them, which would enable them to move, do you agree that then they would have to go into a hotel until shelter space became available?
I would probably say yes in that kind of a circumstance. That is one of those rare circumstances that I was referring to before, where we're talking about the actual service provider and the ability to meaningfully gain that benefit. A person in a wheelchair simply cannot gain the benefit of a shelter if they cannot get into the shelter.
So which part of Judge Wilkins' order concerns you, since you agree that in the circumstance I've described, his order is an appropriate remedy? That is, put the person in a motel until space can become available.
Because the order does not take into account the specific disability need of every family and what is appropriate accommodation for that individual family. I venture to say that none of the families that are subject to this order require wheelchair access to a place and haven't been given it. I just don't believe that's the case. It's a far more amorphous issue, and they're almost all related to circumstances outside the issue of shelter. I'm not disputing that there are unmet needs for these families, but they are not shelter needs. And that is our main concern with the tenor of the order and the analysis of what the department's responsibility is in this circumstance.
All right, thank you.
Thank you, Your Honor.
Ms. Borkin?
Mr. Chief Justice, may it please the court. Plaintiffs respectfully submit the Superior Court's order in this case is not only consistent with, but is indeed compelled by both state law, the Americans with Disabilities Act, and the convergence of the two. Without advance notice to the legislature, DHCD in the fall of 2016 started implementing a practice of no longer placing any new families in hotels or transferring existing families to a hotel, even if that's the only way to accommodate their disabilities that DHCD itself has recognized.
Is that an overstatement, though? They acknowledge that in rare circumstances you can use hotels. They've not eliminated hotels. They've made it the last resort. The judge has decided to make hotels part of the sort of basic, he's returned to the past. He's decided he doesn't like this policy change.
I respectfully disagree, Your Honor. For one thing, and this goes to why this case can be decided just on state law, the proviso in the budget that refers to you shall make hotel expenditures when there are contracted shelter units unavailable.
That's the
was
key.
overridden.
The key is that word unavailable. You and the judge have a different definition of unavailable than the Commonwealth does.
But we have the same definition as the legislature does, if I might.
I don't think you're right.
Because the legislature overrode this veto of that language after Judge Wilkins had interpreted that provisos 3 times.
I thought they overrode the may-shall distinction.
They overrode the whole thing. The governor had vetoed the whole thing. And then the legislature learned about Judge Wilkins' orders, including the one that's on appeal and 2 prior ones, where he very explicitly said, I do not believe that the legislature means that a contracted unit is available when it does not accommodate the needs of people with disabilities.
Well,
and under Boucher
let me
and
just get
Bell-
the question out, and then you can tear it apart for a second, okay? So available, the normal definition of available is there are no units available, as opposed to it doesn't accommodate the needs of a disabled person. Isn't there a difference between those two? And doesn't the judge collapse that distinction? And I won't interrupt you, but that's my fundamental question, is whether there's a manipulation of the statutory language by the trial judge here.
Well, first of all, Your Honor, certainly the word unavailable as used in this proviso in the budget has to be taken into account, taking into other provisions of the line item and other provisions of the budget. And the line item not only talks about unavailability in this situation, it directs the department to take specific steps to make sure that families are close to their home community, including exercising every step to ensure that kids can go to their home schools. And in Section 1 of the budget...
Just to be precise, let's use the exact words of the statute. What are the statutory words as opposed to the judge's overlay? Because I think focusing on the statutory language is helpful here. Go ahead.
Absolutely, Your Honor.
So use...
Okay. First of all, I'd like to point out that because it comes first, Section 1 of the budget specifically provides that appropriated funds should be expended in a way to address the needs of, to facilitate access for persons with disabilities. Then in the line item, the legislature, because they've been so concerned about these families staying close to their home communities, because they recognize just because you don't have a house anymore doesn't mean you don't have a home community. And the legislature first, back in the early 2000s, actually in the 1990s, had said that they should be placed as close as possible to a household's home community as possible, unless the household requests otherwise. They said that if the closest one is not within 20 miles, then they should be transferred at the earliest opportunity. And then, because they still didn't feel like enough was being done to keep kids close, in the 2000s, they added that the department shall make every effort to ensure that children receiving services from this item shall continue attending school in the community in which they lived. And the reason that's relevant to this is it goes to their fundamental alteration argument. The program that the legislature created, and they, even in the enabling statute, General Laws 23B, they talk about administering it in a way that is geographically convenient for families and is fair, just, and equitable. The legislature itself, in creating the EA program, said pay attention to these things, including disabilities and location. And so to say that it's a fundamental alteration, I feel is just not consistent with what the law is, and particularly when you take into account under the law in Commonwealth v. Boucher, 438 Mass. 274, and BHA v. Bell, 428 Mass. 108, when a legislature reenacts a provision after a court has interpreted, and here this court interpreted it 3 times before the veto override, they're presumed to adopt the interpretation of the court. And as we said in our brief, and as the court below found, that when you put all these things together and you take into account the fair, just, and equitable requirement is what their mandate to administer this program, it cannot be fair, just, and equitable to leave children and their parents with disabilities that make it hard for them to even function in the kind of shelters that they're in without a remedy when you have a lawful means at hand to do it. And we understand the policy goal of minimizing the use of hotels, but that goes to Justice Budd's question. Even if that were a worthy goal, and it may not be consistent with the legislature's goal given the override,
Isn't the legislature provided further, the department shall use its best efforts to ensure that the family is placed by the Emergency Housing Assistance Program shall be provided access to refrigeration and basic cooking facilities, which most of these motels, I take it,
Many
don't.
of them do, Your Honor. The one they're using right now, the Home Suites in Waltham, one of the beautiful things about it is that it has kitchens. Many of them do. And in fact, the language, we were all involved in getting the best efforts on refrigeration because then they started providing those things in the motels. They're not mutually exclusive. In general here, the department keeps, their attorneys anyway, keep defending the general policy of trying to reduce use of hotels. And whether or not that policy, which was adopted, at least the elimination of putting any new families, was adopted without advance notice to the legislature, even assuming for purposes of this appeal that
And the
is accurate.
Has the legislature done anything about that? You know, they can act quickly if they feel like they're being thwarted.
And they did. They overrode this veto after they knew about how Justice Wilkins had interpreted it. They only learned about this policy being applied when we learned about it through the litigation and informed them, in spite of language in the line item where the agency is supposed to give advance notice to the legislature when they're changing any policy or practice. And this is a pretty big one, to say that we are going to close our eyes and our hearts to a means of addressing urgent disability needs because of our policy decision. Even if this policy decision is better in general for the generality of families, the very purpose of the reasonable modification provision of the ADA is where in an individual case it is better. The only way you can meet those disability needs is you make a reasonable modification to the policy.
I don't think they disagree with you that there has to be that. If you have that family that you're describing, the wheelchair and the walk-up, or the autistic child in a congregate unit where it's causing a problem. I don't think they disagree with you that may have to at the end go to a hotel if you can't otherwise solve it. But
I hear what you're saying, Your Honor.
Does the court get to reformulate? You keep saying the legislature has dictated this. I need to read this more closely, but I look at this program as having many elements to it with lots of wiggle room. And the legislature could dictate in a sentence that housing shall be available to all, hotels shall be available to all units, and no funding shall be spent.
Yes.
They can do that. You're relying on them getting rid of the word shall and putting in the word shall as opposed to may, right? That's the big change that was over.
I think that one of the key issues in this case is that Justice Wilkins' order does not cut off individualized consideration. It enables that. And here's how it does it. It depends first on their own ADA coordinator. After spending, their process is to spend up to 30 days reviewing medical evidence and conversing with the family and considering other alternatives, such as can we accommodate you in a congregate shelter where you are and make some adjustments, as my brother was saying. Only after that is an ADA accommodation approved that both confirms that the person is disabled and they need a transfer, a different location or form of shelter.
In our record, do you have examples where a person is out of in a unit that doesn't accommodate them, in the record, because I understand everyone, there's competing anecdotes that we have. Tell us where in the record, because you need a reasonable likelihood of success, irreparable harm, and the public interest in your favor. So tell us, because this is a pretty slim record. So direct us just where we go for this, because I'd like to find the support for it.
Yes, and I would have to say that the defendant's use of the term anecdote to describe our clients whose evidence is in this record and are discussed in our brief. There's evidence of, for instance, on page, well, let me just back up. Throughout this case, starting in the spring of 2017, the Superior Court started hearing individual preliminary injunction motions, some of which resolved at the last minute because the defendant decided it. So there's a whole series of individual preliminary injunctions. Then in August, before this order was issued, there was a motion on behalf of 18 different families who had been waiting for months after their individualized accommodation request was fulfilled to get a transfer.
And we have that
One
all
of them is on page 14, MF, a grandmother caring for her grandchildren. They all have serious mental health issues. They received critical neurological treatment for the children at Boston Children's Hospital. They were placed all the way in Framingham.
And just so I remember, from your brief, NF, the disability is they're too far away from the hospital? Is that the disability? That I'm trying to understand, because again, the core function is shelter, but obviously shelter may impact on their disability. I'm trying to understand, NF, the problem with the accommodation for NF was what?
That, one, she was in a congregate shelter, which was inconsistent with her own mental health needs, and her mental health deteriorated as a result of being in that congregate shelter, and the great difficulties of getting her grandchildren to very critical medical care and the traveling back and forth meant that they were not able to take advantage of the housing search services in the program. And that's the same also with clients who are in our brief and in the record, RF and IM. They're placed so far away that their disabilities were triggered. They had to spend all their resources going to these critical medical appointments, something that would not happen for persons without disabilities. They have to spend all their resources on that. Then they don't have the opportunity to engage in the housing search function that other people without these disabilities have. And I'd like to remind you that these are people who...
Just so in the record, because again, we're stuck with a record. So in this record, what was the reaction? I take it, did your clients complain to the department about the accommodation and request an individual? Is there in the record, because your brother just stood up and argued, we would do this. If we would go through an individualized inquiry, and again, we're not going to default to hotels right away, but we would try to, is this record going to allow us to analyze NF, RF, and IM?
Absolutely, Your Honor, and that we have 2 volumes of a record appendix. They're full of all the affidavits and ADA approvals that were before the Superior Court. There's quite a bit of evidence for a preliminary injunction here, Your Honor, and it's very family specific. And some of the families, because they waited so long, again, after the ADA coordinator approved the accommodation, considered other alternatives, and then approved the accommodation, they had to wait for months. And some of them, because the conditions got so bad, including the mental health of NS on page 15, that they, in spite of being so desperate for shelter, had to leave the shelter system and go sleep on a floor someplace in order to be able to access that mental health treatment. I find that my brother's argument that we accommodate people with physical disabilities with respect to access, but we don't accommodate people with respect to other kinds of disabilities that make shelter virtually unusable, stating a form of discrimination among people with disabilities, which was exactly what the Supreme Court addressed in Olmstead. And if I may...
Well, can I just, one question. I find the judge's order the actual order has 2 components to it. notwithstanding its policy on motels, DHCD shall treat motels and hotels as available placements when implementing approved ADA accommodations. If a hotel or motel placement will meet an approved ADA request for an EA recipient and DHC cannot provide any, a hotel must be provided. But what is your understanding of what the judge has done in terms of, what does this injunction do to the availability of hotels? How does it change how does it change versus what the department was, which was they will do it as a last resort? What do you understand Judge Wilkins to be imposing here?
I understand that with respect to the first paragraph, he's saying to the agency, do not take hotels categorically off the table in considering whether or not they, how you can meet accommodations. It's very similar to the Supreme Court.
I just want to try to be precise, because they are arguing we didn't take it categorically off the table. They will admit they have made it a last resort. So what are you saying that the judge is doing? Because they are not taking it categorically off the table.
With all due respect, Your Honor, their argument here today is not consistent with the record in this case or their practice. They did take it categorically off the table. In fact, the record shows that the client RF, when she was approved for shelter, they didn't have any space for her, none. And they still didn't use an EA shelter hotel. They called somebody else up and asked them to rent a hotel because they were so resistant to using a hotel within the EA program. I'd just like to say that this is...
So just so I understand, so you're saying that they have categorically taken, they are misrepresenting to us what they actually do, that they have, you're saying that they have categorically, even, that they will not even put the wheelchair person in a hotel. They will not do anything.
I don't know about that, Your Honor. We haven't seen that example, but I do know that they left, at least they've left families without any shelter. They left NS to have to leave the shelter system. They left the named plaintiff, Dawn Didion, without any shelter because they refused to use a hotel. So that goes to, have they ever really interpreted this unavailability the way they said? I would like to say that this notion of taking too rigid rules off the table is exactly what the U.S. Supreme Court did in PGA Tour versus Martin. They not only there ruled that Mr. Martin should be able to use a golf cart, they in general ruled that the tour refusing to even consider using golf carts for people with disabilities is a violation of the ADA, and that's very analogous to what we have here. The judge's order here is also very like the order in Olmstead, where it says transfers from institutional sites to community-based programs are required by Title II when treatment professionals determine that such placement is appropriate, the affected persons do not oppose such treatment, and the placement can be reasonably accommodated, taking into account the resources available. And here, I wanted to make one point. There are the two elements of the judge's order that you mentioned, but in addition, there's really a third that he thought was always implicit, but he made very clear in the motion for reconsideration, which is in our addendum on page 38, that he's also saying, of course, the families don't have to take a hotel if they, in consultation with their medical providers, feel like it will not accommodate them. So that's another way that individualized consideration is taken into account. It's taken into account at the beginning with the ADA coordinator. Then it's up to DHCD if they can find some other place. It's the other thing the judge kept saying. I'm not saying you have to use a hotel if you can accommodate people through the other available portfolio. But what you can't do is just leave them languish there without any alternatives in sight. It's a reasonably near site.
Say there, what do you mean? Languished in a unit or languished without a unit?
Both, Your Honor. Sometimes it's languishing in a unit that triggers the mental health problems. Sometimes it's languishing in a unit that means you're going without care that is essential because of your disability-related needs. None of these ADA requests are approved on anything other than disabilities that are found by the ADA coordinator. And then finally, the judge said, said that you look at After you've looked at seeing whether there are any other options, you converse with the family to make sure that a hotel will meet their needs. There's individualized consideration throughout this.
Reasonable accommodation. What does our case law say as to what is the time period that is reasonable to accommodate? I gather it probably varies a little bit with the nature of the problem, but what does our
I think
case law
it does, Your Honor,
say?
and there's not a lot of case law on that, but for instance, the court below actually cited that the court in Olmsted, at least a plurality of the court, had said that it would be one thing if there was some well-defined waiting list that moved with reasonable speed. Here, all that happens is they're told you when it's administratively feasible, and yet they admit they can't add any more congregate units in areas of high demand because those are too complicated. They can't add any more scattered sites, or that it's very difficult. I shouldn't say they can't add any, but that it's very difficult for them to do that, and it would take a long time. So they're proposing to say that these families just languish even though they could use a hotel room. We think at a reasonable time under this scenario, no one said immediately transfer them. What the judge said is once you figured out that you don't have any other place, there's an approved ADA, you don't have any other place, now you engage in the interactive process to find out with this family, in conjunction with their medical providers, whether a hotel is better for them, better for their disability-related needs than what else can be offered in the system. The department keeps saying that hotels are bad, but as the Superior Court ruled, they're not always worse than what you've afforded them in light of their
That's the
disabilities.
standard better? You used the word, you used the word better for them. The agency in Boston is doing better, keeping people in their community. That's a really important goal. Maybe not for every family, but for most, you want to keep them, if you can, in the same school. So the agency seems to be at least staying the same or hopefully getting a little better there. We'd like to see more. But at some point, if somebody's moved because it's better for their disability, which I think is the words that you just used, then somebody else can't be in that spot. Doesn't the movement have to be, this is just if I can finish the question, doesn't it have to be that they have to be moved because if they're not moved, there's discrimination based on a disability?
Failure to make reasonable modifications to accommodate a disability is discrimination under Title II of the ADA. So that where you have the means at hand, you must use that option, or that qualifies as discrimination under 35-130B7 or whatever it is. And I really would like to respond to Your Honor's point because I do think it's very important. The whole reason why the court below focused this order on use of hotels is precisely because no one else has to get moved when you use hotels. Hotels are an expandable and contractible supply of shelter. DHCD, as they say in their affidavits, you don't, unlike other forms of shelter, you don't have to pay for it when you don't use it. And because it is expandable, you can just get another hotel room without having to displace anybody. And that's why this order is so narrowly tailored and does not cause any harm to other families because it's the one form of shelter where you can just add on capacity without doing a whole reprocurement.
But it has other cost consequences, right? They need to go monitor the hotels. They need to inspect them. They need to spend money on those as opposed to building the congregate or the individual. It has consequences, right?
I think there was
course it does.
mention of security, and I think perhaps in the agency brief as it related
It
to
does.
hotels by way of example.
Excuse me, Your Honor. In the record, and the Superior Court kept asking the department to produce any evidence as to the relative cost of hotels, even including services, and they never did. But we got discovery, and we did. And there, in an affidavit from one of my colleagues, Linda Garcia, there is cost estimates based on documents from them that hotels, even including the services that you're referring to, Justice Casper, cost less or certainly no more than congregate shelters or scattered site shelters. And DHCs agrees that congregate is the most expensive form of shelter. So we're simply asking, as this court said in Smith versus Commissioner of Transitional Assistance, time presses sharply on a family with children struggling against destitution, and therefore that relief may sometimes need to be offered in days, not weeks or months. We're asking you to please be cognizant that time presses even more sharply on families struggling not only with destitution and homelessness, but the extra burdens that disabilities bring. And we ask that you order that the stay be lifted immediately and affirm the Superior Court's order.
All right,
Thank you.